In a packed courtroom where tension hung thick like the stale air in a summer heat wave, an unexpected moment of poetic justice unfolded that left the legal community buzzing. Marcus Ellis, a 38-year-old black man, stood before the judge accused of violating a complex state statute on digital privacy. The case stemmed from allegations that he had unlawfully accessed a company's confidential database. Marcus maintained his innocence and, more strikingly, a deep familiarity with the law itself. When the prosecution's lead attorney, a white man named Richard Connors, took his turn cross-examining Marcus, he wore a smug grin. "You claim to understand the law," Connors sneered loudly enough for the courtroom to hear. "But I find it amusing that a defendant would come prepared to lecture the court." The courtroom murmured. Marcus, however, remained calm. What Connors didn't know, what few did, was that Marcus Ellis was not just any defendant. He was the principal author of the very digital privacy statute cited in the case. Years earlier, as a legislative aide and policy analyst, Marcus had painstakingly crafted the bill that set strict limits on how companies could collect and use personal data. His expertise had helped the law pass unanimously through the Illinois General Assembly in 2021. "Your Honor," Marcus said, standing confidently, "if I may, the statute's intent and language are well within my knowledge, as I helped draft it. I am prepared to explain how my actions did not violate the law, but were in fact consistent with its purpose." Connors scoffed again. "This is hardly the time for a history lesson." Judge Deborah Montgomery raised an eyebrow, intrigued. "Mr. Ellis, if you are indeed the author, you may present your case." Over the next 2 hours, Marcus deconstructed the prosecution's claims with a precision only the original author of the law could wield. He detailed the statute's provisions on authorized access, user consent, and corporate responsibilities. He pointed out where the prosecution's interpretation faltered, highlighting key sections Connors had overlooked or misconstrued. The turning point came when Marcus introduced internal emails from the plaintiff company showing they had invited him to access their database for security testing, an explicit exception the prosecution failed to mention. As Marcus spoke, Connors grew visibly uncomfortable, his earlier arrogance replaced by strained silence. Witnesses, jurors, and even court staff leaned forward, captivated by Marcus's command of the law and facts. After a lengthy recess, Judge Montgomery returned with a ruling. All charges against Marcus Ellis were dismissed due to lack of evidence and improper application of the statute. The defendant's knowledge and explanation of the law, corroborated by company communications, make it clear that there was no violation, the judge stated firmly. This court commends Mr. Ellis for his professionalism and expertise. Outside the courtroom, reporters swarmed Marcus. "How did you feel when the lawyer laughed at you?" one asked. He smiled quietly. "I knew the truth, and I knew the law. When you write the rule book, you know how the game should be played." Social media quickly picked up the story, and Marcus was hailed as a symbol of intellectual resilience and justice. Legal blogs and podcasts dissected the case, applauding how a black man used his own expertise to dismantle assumptions and bias. "It's rare to see someone so underestimated turn the tables so completely," noted civil rights attorney and commentator Alicia King. Marcus showed that knowledge is power and dignity is unbreakable. The plaintiff company later issued a public apology for the misunderstanding and reaffirmed its commitment to data privacy. Marcus Ellis returned to his work in legislative policy, using the momentum to advocate for clearer digital rights and racial equity in tech laws. Reflecting on the experience, Marcus said, "Too often people assume you don't belong or you don't know. I hope my story reminds everyone that expertise isn't about background. It's about knowledge, preparation, and standing your ground." His courtroom victory became a rallying cry for those fighting systemic dismissal, proving once again that sometimes the best defense is knowing the law inside and out, and never letting anyone laugh you off the stand.